Breaking news, folks. The United States Department of Justice has just taken a dramatic legal step on the issue of whether so-called large-capacity magazines, those holding more than 10 rounds, are unconstitutional under the Second Amendment. And let me tell you, this is one of those stories you do not want to miss, because it could reshape the entire debate over gun rights in America for years to come. Stay with me as we walk through this, because I promise you, this story is both historic and a vivid example of how law and politics can change direction in a heartbeat. First, let's talk about the specific case that brought all of this to the surface. An individual, identified in the case file as Tyree Benson, had been charged and convicted in Washington, D.C. for possessing a magazine that could hold more than 10 rounds. According to D.C. law, that kind of possession was a criminal offense. Back in November 2022, he was indicted on multiple charges, including carrying a pistol without a license, possessing a large-capacity magazine, possessing an unregistered firearm, and unlawful possession of ammunition. By April 2023, following a bench trial, Benson was convicted on all counts. Naturally, he wasn't about to accept that quietly, so he filed a direct appeal. The D.C. Court of Appeals heard oral arguments in December 2024, and the case has been pending ever since. Now here's the key. Throughout that period, the Justice Department under the prior administration had insisted that the large-capacity magazine ban was constitutional, and that Benson's conviction was proper. Their argument was simple. The Second Amendment had not been violated, and the government retained the authority to restrict weapons or accessories it deemed dangerous. That was the prior administration's position. But now, everything has changed. The Justice Department under the current leadership has officially reversed course. And not only that, they have filed a motion asking the court to vacate Benson's conviction on the grounds that the statute itself is unconstitutional. Stop and think about that. The federal government is openly admitting that a law banning these magazines violates the Second Amendment. That is something we haven't seen in years. This kind of reversal is rare in American legal history. The Department of Justice does not casually abandon positions it has defended for years. For the government to step forward and admit that a statute it once stood behind is now unconstitutional is extraordinary. It signals not just a technical shift in litigation strategy, but a fundamental recognition that constitutional rights cannot be brushed aside by changing political winds. That is why this case matters. It represents a direct acknowledgement by the government that the Second Amendment carries binding weight even against policies once seen as untouchable. Why does this matter so much? Because the Second Amendment plainly says, the right of the people to keep and bear arms shall not be infringed. Magazines, in their very function, are integral to the operation of a firearm for self-defense. If a law prohibits all magazines over 10 rounds, that is essentially banning an entire class of firearms widely used across America. And this is precisely the core argument the Justice Department has now laid out. Such a law cannot withstand constitutional scrutiny. This move also opens the door to reconsidering past convictions and ongoing prosecutions. If a law is unconstitutional, how can any citizen be considered a criminal for violating it? And when the federal government declares that it will no longer pursue prosecutions under this statute, what we're witnessing is a wholesale shift in how the law will be enforced on gun rights. This isn't just about one man named Benson. This is a statement of policy, and it could impact millions of Americans who own the very magazines that D.C. and other states have tried to outlaw. The most striking thing about this reversal is that it isn't random. It is directly tied to principles the Supreme Court has already laid down in landmark cases. Remember District of Columbia v. Heller In 2008, in that case, the court held that DOJ's total ban on handguns was unconstitutional because it eliminated an entire class of arms commonly used for self-defense. The court made it clear if a weapon is in common use by law-abiding citizens for lawful purposes, it cannot be banned outright. Fast forward to 2022, and New York State Rifle and Pistol Association v. Bruen took that principle further. The Supreme Court emphasized that restrictions on the right to bear arms must be consistent with America's historical tradition of firearm regulation. You can't just invent modern restrictions without historical grounding. And when you apply that reasoning to large-capacity magazines, the Justice Department concluded that there is no strong historical basis to support a total ban. That is why, in its motion, the department stated plainly, a magazine is an arm under the Second Amendment because it directly enables armed self-defense. If a component makes the firearm function in a defensive capacity, then it falls within the amendment's protection. Once you recognize magazines as arms, the right to own them is guaranteed, unless the government can prove they are both dangerous and unusual. But here's the problem for the government. Tens of millions of Americans own these magazines. With hundreds of millions in circulation, they are anything but unusual. To understand just how widespread these magazines are, consider this: they are not limited to one niche of society. They are standard equipment for many police departments, for members of the armed forces, and for millions of civilians who own semi-automatic pistols and rifles for lawful purposes. Walk into any gun store in much of the country, and magazines exceeding 10 rounds are simply the default option. This fact undercuts the idea that they are exotic or unusual. The truth is, they are part of everyday ownership and training, woven into the very fabric of how firearms are designed and sold in the United States. And under Heller, the burden of proof rests squarely on the government. It must demonstrate that the banned item is not in common use and is exceptionally dangerous. With the sheer numbers involved, there's no credible way to argue that magazines over 10 rounds fail the common use test. That makes any ban legally flimsy. Here's the contrast: the previous administration justified the ban on the grounds of public safety, arguing that the government had leeway to impose restrictions for collective good. The current administration has pivoted sharply, declaring that public safety cannot override a clearly enumerated constitutional right, unless compelling historical evidence supports the restriction. That is a foundational policy reversal and a clear signal that the Second Amendment is now being defended with new vigor. This isn't limited to Benson's case. When the Justice Department signals that it won't prosecute similar cases, that message will ripple across the country. Lawyers in states like California, New Jersey, or Illinois can cite this shift in federal position to challenge their own state laws. Cases like the Barnett case in the Seventh Circuit or the Duncan case in California now gain tremendous momentum. And if any of these cases reach the Supreme Court, the federal government will no longer stand with the bans, but instead align itself with the Second Amendment. That's why this moment is being hailed as a milestone. It's not just about one conviction being vacated. It's about the federal government officially acknowledging that a popular ban cannot withstand constitutional review. And once that acknowledgement is written into legal filings, it becomes a reference point that other courts can use, and perhaps even the Supreme Court itself in the near future. So what does this mean in practice, first and foremost? It means the federal government has now made it clear that it will no longer prosecute individuals solely for possessing magazines that hold more than 10 rounds. That alone is a seismic shift in policy. For years, thousands of Americans faced the threat of serious criminal penalties for owning something that tens of millions of people consider ordinary. Now, with the government stepping back, Citizens are directly shielded from enforcement of a statute that cannot stand on constitutional grounds, and the impact extends far beyond the Capitol. When a federal agency declares that large-capacity magazine bans are unconstitutional, that instantly provides ammunition, no pun intended, for attorneys fighting similar laws in other states. Every lawsuit in California, New Jersey, Illinois, or anywhere else can cite this federal stance. What was once a narrow local battle now takes on national significance. Cases already pending in appellate courts, such as Barnett in the Seventh Circuit or Duncan in California, will gain newfound strength. If any of those cases make it to the Supreme Court, the federal government will not be on the side of bans anymore, but instead on the side of the Second Amendment. That is the complete opposite of the role the federal government played before, when it defended restrictions. Now, the tables have turned, and that reversal could prove decisive. But this development is not just legal, it's also symbolic. For the millions of Americans who believe in the right to self-defense and the right to keep and bear arms, seeing the government openly acknowledge that such a ban is unconstitutional is deeply affirming. It sends a message that their voices are being heard, that the constitutional protections they've long defended are finally being respected. It energizes the community, inspires confidence, and fuels further advocacy. There's also a political dimension. Lawmakers in states that have embraced strict magazine bans are now put on notice. If the federal government won't back them up, maintaining those bans becomes increasingly difficult and politically risky. Passing laws that are destined to be struck down wastes resources and creates division. The shift at the federal level will pressure local politicians to rethink their approach or risk backlash from voters who see their rights being trampled. Of course, the fight is not over. Many states will continue to defend their restrictions and argue in court that their bans should remain. But with the Justice Department's new stance, the balance has shifted dramatically. Supporters of the Second Amendment now have strong reason to believe that future litigation will trend in their favor. This is more than a legal win. It's a foundation for many victories yet to come, and that is why this moment is truly fantastic news. It doesn't just set one man free from a questionable conviction. It affirms the principle that the Constitution remains the ultimate authority, that the rights of the people cannot be erased by statutes lacking constitutional grounding. We are watching a turning point unfold, a moment when the federal government openly stands with the Second Amendment. And make no mistake, this is only the beginning. More developments are on the horizon, and this wave of constitutional defense will keep spreading across the country.